Welcome to Tennessee Court Talk. This episode is a discussion about technology in the courts. Your host is Tennessee Supreme Court Justice Sarah Campbell, and she welcomes a panel of Chief Justices from around the United States to discuss how their respective judicial systems are handling the ever-changing world of technology, from positive uses of artificial intelligence, to improved access to justice, to civic education, to making data and court proceedings more readily available, and the different ways states are innovating. Recorded at the 2024 Conference of Chief Justices in Nashville, Tennessee, Justice Campbell talks tech with Chief Justice Mary R. Russell of Missouri, Chief Justice Elissa Cadish of Nevada, Chief Justice Elizabeth Clement of Michigan, and Chief Justice Ann Timmer of Arizona. Here's your host, Justice Sarah Campbell.
Welcome, everyone, to Tennessee Court Talk. We are in for a treat today. We have here as guests 4 Supreme Court justices, 3 of whom are Chief Justices of their respective state Supreme Courts. Today's topic is technology in our state's judicial systems. To get things started, I want to begin with a high-level question. Why should we care about technology in our court systems?
Well, it's our job in serving the public to do the best we can to administer justice in a way that's fair and efficient and allows access to justice for all litigants. And so at this point in time, technology is an important part of that, not only making available our decisions through various technological tools that are available, but to allow them to file things. And it would seem sort of in the dark ages to require everybody to be mailing in everything they're filing anymore, to have wet signatures. At least that's how it seems from my perspective.
Thank you, Justice Cadish. Anyone else want to weigh in?
I agree entirely with that. I would add that I'm really excited about the usefulness of technology as far as solving some of the problems we have with our legal deserts that I think really in all of our states we have. We have the haves and the have-nots. And if you're in an urban area, you would sometimes have greater access to the court system than you do if you live in a rural area. Technology can solve that and has a great, I think, great capability of evening the playing field, so to speak, for people. So that's very exciting.
And it provides efficiency in how we do our jobs. We can do things so much faster because of the advantages of technology. And then I'd also add, it provides transparency so the public can see what we do and have more confidence, the more knowledge they have about how we do our jobs.
In Michigan, we found that court users, they don't want to be coming to the courts. They're usually having something going on in their life that requires them to interact with the court system. And technology is a way to give them faith in that system, but also address the realities of their lives, which is it's difficult to leave work, it's difficult to get childcare. And so with court technology, we can make the user experience that much better.
I think technology is something that court systems across the country are thinking carefully and deeply about how we can harness it and use it effectively to improve the experience of litigants and others who interface with the system. I'd love to hear more about ways in which your states have successfully embraced technology in recent years.
In Missouri, one program that we're really proud of is called CaseNet. And CaseNet allows the public to have access to all public cases and documents at all levels of the court, from our municipal courts all the way to the Supreme Court. So every single court in our state is connected to CaseNet. So it's a popular tool if people want to perhaps see a particular litigant has any judgments against them, has any lawsuits pending against them. If you're in the dating field, you might want to check and see if this woman or man is appropriate to date. If you're a landlord, you might want to check to see if they have any judgments against them for unpaid rent. So we're not aware of any other state that has this kind of public case information system that any member of the public can get on now.
We don't have, in Nevada, we don't have a unified court system. And so while we're sort of the head of the state judiciary, it's really just by virtue of the bully pulpit, if you will, and rulemaking. So the Supreme Court, for some time, and our appellate courts have had the availability online of our decisions. And during COVID, we made available all the briefing and filings that had happened in a case to the public through the public-facing part of our website. And the courts in our most populous counties, Clark County, where Las Vegas is by far the biggest population, and then Washoe County, where Reno is, both of those have had electronic filing for some time now. But as was referenced in terms of legal deserts, we also have some difficulties with the courts in the rural areas having the resources and the motivation perhaps to get up to speed on making available the filings electronically. And we're now currently in the process of approving a system or making available as a resource for the Supreme Court an e-filing system that can be established and used by all the courts statewide. We've rolled that out now with some of the courts. So instead of forcing them to do something, we're saying, okay, now we have it available, come sign up. And we're actually considering some rules next week in a public hearing that are going, at least as proposed, would require e-filing to be available in all the courts throughout the state. So that'll be a big step if we're able to make it happen.
Yeah, well, we're doing very similar things in Michigan with our e-filing and rolling that throughout the state. And we have really committed to, since the pandemic, to remote hearings. We've always, at the Supreme Court, have always posted all of our oral arguments on YouTube, but we got 900 licenses for judges and magistrates during the pandemic. And I think we were the first state to get everybody to get all of the courts up and running remotely. We continue that work. We've passed rules to allow for hybrid and remote hearings to continue that service to the public with, mixed results. We hear, both positive and negative depending on what type of case, what type of litigants, and needing to stay on top of that and get that feedback so that we're responding to not just the court users, but courts around the state as well.
It seems like during the pandemic, I've heard it said that we had 10 years worth of innovation in about a month. And I think that's true. And there's no going back at this point. The public has gotten a taste of virtual appearances and e-filing and all of that, and they want more. Our funding issues be damned. They want to go forward. I'll bring up another aspect of technology, and that is people's ability to participate in jury service. We've had a lot of innovation in the area of virtual questionnaires, so you can start your jury selection while they're at home and screen people out. We have one county that still continues to do their grand juries entirely virtually. It's a county that is bigger than some states back east, and the distances are just vast. And if you're called in jury duty, if you live in some place called Colorado City, to get to Kingman, you have to go through Nevada, drive down, and it's a 4-hour driving distance. That's quite a burden for people. So they've had tremendous success with juries being done, grand juries and jury selection mostly being done virtually. And I think that they will keep that up. And we're going to expand on that with case-specific questionnaires to enable people to minimize the time they have to spend coming down to the course, which I don't understand why everybody doesn't love to come down to a court, but apparently they don't.
Chief Justice Clement and Justice Timmer, you both mentioned ways in which the pandemic accelerated your adoption of technology and perhaps the public's expectations about technology. I'd love to hear any thoughts that Chief Justice Russell and Chief Justice Cadish have about the pandemic in particular and how that affected technology use in your states.
Well, I think likewise for what both the chiefs from Michigan and the chief to be in Arizona have said, we've seen the same thing, for proceedings that do not require the swearing of a witness, the taking of evidence. They're very commonplace in our trial courts and very popular. It's something that I don't think we ever go back from either. But, it really saves someone for having to make a court appearance when they can maybe just go to the break room and take leave during the middle of the workday, or maybe from the comfort of their home, or to go out to their car and leave work and make the call into the courthouse and have some privacy. But it's those kind of conveniences that I never imagined before, but they work and justice is done and due process is followed, and it's a win-win.
So similarly in Nevada, we learned, of course, quickly to do things remotely and to have hearings remotely. But at the same time, I think what it showed us is which kinds of hearings or proceedings that works well for and which ones it really doesn't. I mean, you do it when you have to do it, but certainly our arguments before the Supreme Court are much better, I think, for everybody when they're in person. We had remote arguments when we needed to, but it's not ideal. Similarly, we formed a commission that just finished its work a couple months ago to do a study on virtual appearances for various kinds of proceedings in criminal, civil, and family matters. And we've set up a series of presumptions for different kinds of proceedings. Is this kind of hearing presumed that it's going to be a remote hearing going forward, or is it the kind of hearing that is going to be presumed to be in person? Something like evidentiary hearings, or if you have in a felony criminal case, you have someone coming in to enter a guilty plea, you really want to be looking that person in the eye when you do that. And certainly trials and evidentiary hearings, you want someone to be in person if you can make it happen. There are some exceptions also, and again, it's just presumptive categories. So if there's a good reason to flip the script to say something that's presumptively in person should be remote for a particular reason, that's fine. But we had a lot of participation around the state, and we just adopted in the last month or so these presumptive rules, and now we'll see how that looks going forward. We've set it up to look at it again within a couple of years and see how's it going, and do we need to make changes now that we're trying it this way.
Justice Timmer, I believe you mentioned in your comments earlier that funding does not always comport with what the public wants to see in terms of technology. Are there other challenges that you have experienced in deciding how to move forward with technology in your state?
In funding or in
any other funding, if you'd like to elaborate on the funding issue, and then any other challenges.
Oh, sure. Well, funding is a challenge because for whatever reason, years ago, all of our technology in the court system is tied to people having fines and fees. And people apparently aren't pulled over as much, or they're more law-abiding, because in our state at least, and probably others, so those kinds of fees, such as fines, have plummeted. But that's our source for technology. And at the same time, of course, demands for technology expansion have increased. So one of our goals is we need the legislature to put us on some kind of general fund funding, which is a bad time right now to ask for that. And it probably won't happen in the next year or two. But that continues to be a source, along with the fact that our funding in our county courts doesn't come entirely from the state, it comes from the county. So you have different counties with different resources and different boards of supervisors. And we've been speaking with some of them in the rural communities this past week, actually, some of the border communities, on trying to impress upon the boards of supervisors the importance of technology for their citizens, or we're going to be rapidly left behind with where the court system is going, and that's not fair to them. So that seems to be our major impediment with that and getting everybody on the same system. We're not unified. We're not like Utah. Utah's a great state. They have everything on one case management system. Ours did not develop that way. And so now we have all of these disparate parts. And so we're working a lot on, through the National Center for State Courts, with the nods, with the data elements, having standardization so that when things are put into place for all of the different case management systems, they can talk to each other. We know what we're using the same terminology. And that's been an incredibly tough lift, reaching that. So that's probably our other big problem, or just disparate parts.
The funding issue is different depending on what state you're in. And when you said how difficult that is, and I'm thinking of, we're not a unified system either, but we recently got $150 million to create a statewide case management system, which was incredible that we were able to secure that from the legislature and the governor, and had their full support, because we recognize, and I think everyone does, that without that data, the policy making behind it and the decisions that not only that we make at the court, but that the other branches of government make, they need that data. They need it to be apples to apples comparisons. And so that's one of the huge projects that we're focused on. And we're very lucky that we have that financial support, because without it, you just keep moving ahead with the system that you have and trying to cobble things together.
We're lucky to have a court automation fee. So it's a $7 fee court cost on every case that's filed. That goes to our automation fund, which is really good. And it helped fund initially our automated statewide court case management system, like the CaseNet program that I talked about earlier. But then we also need general revenue, and we try for grants. But the other resource that's challenging for us is personnel. IT people are in high demand. Government probably doesn't pay as much as the private sector. So like a lot of fields, and we're always looking and needing more more capable, competent people to help us in our IT field.
You need to be able to retain them.
Yeah.
Yeah, we've had also in Nevada quite a bit of turnover in IT people. I think we've got a good group now, and I'm hoping we'll be able to hold on to them. And we were able to, in the 2023 legislative session, get raises for our employees. So that's a good thing that hopefully will help us, because we were losing people like crazy, which you understand. I think people need to feed their families, and hopefully with holding down one job is enough to do that. But it's tough.
Right. We have, we in Tennessee are struggling with many of the same challenges, and in particular, the challenges that come from having a non-unified system. I know we've heard already from both Arizona and in Michigan. You all face similar challenges in not having a unified system, with funding coming from various places. So are you in Missouri and Nevada? Do you have a more unified system?
Yes, we are unified.
Or completely unified?
Yes, and have been since about 2011. E-filing started back then.
In Nevada, we are not a unified system, so we have some of the same challenges you've been talking about, although we're hoping that now us getting the e-filing resource available and adopting rules making e-filing mandatory will get the other courts that haven't moved that way to do so. And we're also working on the data gathering project similar to what Arizona is working on.
It's interesting that improvements in technology can take a non-unified system and get it closer to what a unified system looks like just with technology. So we'll in Michigan, we'll never have a unified system. But I think with all of the changes that we're making with technology, we're going to get very close to looking like a unified system.
Right. Unification in at least certain respects. Yeah. Unification of data.
Yes.
Data collection and data reporting.
At least to where an attorney who is, attorneys may practice in multiple counties, right? And each county is a separate district court system. And so at least we hope to be where if the attorney is sitting in Reno, they can file in the Washoe County District Court, but they could also file in Lyon County or Carson City or Story County, which are all within an hour's drive of Reno. And because if everyone is a separate system, it's just unnecessarily complicated and difficult and requires additional resources, and it can be confusing. And that's with attorneys, and that's before we even talk about people who are unrepresented trying to navigate what court they even go to. And one thing we've also worked on through our Access to Justice Commission, and we got a grant to put these kiosks in public libraries around the state that have information and self-help forms for filing. And part of what is built into that is you put in where you live to try to at least direct you to the right court system. And then if it's like a small claims type matter or a landlord-tenant matter, then it's not even in the district court. So you're figure out which justice court within the county that you're going to be in. But hopefully through the directed questioning, we're getting people to at least the right forms with the right caption. It's not easy.
Well, as your answer just, I think, alluded to, there are a whole lot of groups that you really have to bring along when you adopt any sort of technological innovation. And depending on the innovation, there are different groups that may be involved. Have you found any successful ways of doing that might be helpful to pass along to our listeners? Or are there challenges that have been roadblocks that you might not have been able to overcome yet?
Well, in Arizona, we have a Commission on Technology, which I happen to chair at the moment and have for the last 5 years. And that simply oversees all technology, even though it's not a unified system. So there are certain data standards that we adopt and that all the courts have to abide by. And if they want to vary anything, if it's like the city of Phoenix, they're currently doing a new case management system. And so they have to get permission from us and sign off on it to make sure that it's something that we want to permit. And we don't want too many disparate systems. So for them, we'll probably approve it, but just say you have one large limited jurisdiction case management system, and the state can have a small jurisdiction case management system, and that's it. Those are the two buckets. So things like that we're trying to do, as you said, in Michigan, we've got a disparate system, but we're going to try to bring it up to certain standards so that we can implement new things across the board. So that's at least how we've approached it.
I think change is difficult, especially in an industry like the judiciary and the law. And you've got lawyers, and we've had a lot of judges that are kind of set in their way of how they like to run their courtroom and looking in books and writing everything. And, so I think the important thing is to recognize that when you're making changes, especially with technology, that you're going to have different levels of comfort across the board. And I think education is the key, explaining why that we're not adopting new technology just for the sake of adopting new technology, but what the goal is, and that it's to serve the public better, and that is our job, whether you're a judge or whether you are an attorney working in the judiciary and working in the system, that our goal is to serve the public, and trying to keep that at the forefront of why we're making changes with technology. And then, like I said, a lot of education. I think the more education that you can give someone, even if it's repetitive, I think that helps get people more comfortable with change.
I think you've hit on an interesting issue, and that is interfacing with other of our judicial partners. We struggled for a while, but now we do exchange data with both state and federal departments. Like, for example, one of our most recent projects was implementing electronic warrants, so that we have real-time sharing warrant information and warrant recalls. So that's been another big hurdle to get over. But allowing those other judicial partners that work with us to be able to have access in and access out and exchange of data and information is real key.
I was just thinking about sort of a little bit different direction, but just that on the one hand, we have some self-represented litigants who have pushed us, like, why aren't you allowing us to e-file when you have attorneys e-filing? But at the same time, we have to be cautious, because then if we've made it mandatory for attorneys, but we can't make it mandatory for self-represented, because while some of them are pushing to have the opportunity to do so, some simply won't have the resource or the availability of the technology to do it. And so we can't just put everyone in the same bucket and say, well, mandatory e-filing for all, this is great, because it won't be great for some, and you still need to allow there to be some exceptions to do your best to allow everyone to participate in court proceedings if they need to.
That's a great point. Thinking back to remote hearings, we said some things make sense to do remote hearings, but there may be individuals that, for whatever reason, don't feel comfortable or don't have the resources to do it. And we need to make sure that the courts can respond to all of those situations, even when we're moving forward with technology.
So what we do with someone is pro se, they'll bring their paper document in, and the clerks scan it into our e-filing system, and so it becomes part of the electronic record. And then we also have kiosks at every courthouse that people could enter in or utilize some of the forms that we have online. But we don't have any barrier that prevents people, because they're pro se, from being able to file.
And I think that Justice Russell brought up something really interesting that I would be curious about you all think, and that is working with other justice partners that, like the e-warrants, and we have e-warrants and protective orders and all of those types of things, which is great that other partners can access, but along with that means that other people can access it, and we don't control those other agencies as much as we would probably like to for that kind of thing. So you have to start worrying about, well, what's their security like on their end? We're now opening our doors, so to speak, to them to come in, and we have some real cybersecurity issues there. And we try to set standards, at least in the courts, with firewalling and whatnot, but we don't know. I mean, and our nightmare is if somebody in the Parks and Rec department all of a sudden opens a weird email and it ends up funneling through and going off the judiciary. So I just wonder if you all experience that when you work now. Increasingly, they want us to work with other partners in government.
I don't necessarily have that experience, but it just reminded me about, we're going to putting more and more on the cloud through obviously secure cloud sites, and our technology experts, which I'm certainly not one of them, tell us that if we do that, those resources have staff whose job is to make sure it's secure, whereas if we keep it to ourselves and don't put it in the cloud, then we would have to hire more staff, more IT people to be monitoring everything more than we already are. And we know there have been several states and other government agencies that have had bad people take down their sites or demand ransomware attacks and things like that. And we always have to be concerned about those things. So, we use the technology and we want to put more and more available so we can access it wherever we are. We carry our laptops everywhere and need to be able to access all of that. But we also need to be mindful of the other side of that, is what risks does that open up and how can we best prevent improper access to our materials?
Well, and I think, this conversation well illustrates why change is often very slow in the judiciary when it comes to technology, because there are so many countervailing interests to consider. You hardly ever hear the words cutting edge used to describe technology in the judiciary. And, there could be multiple reasons for that. But, there is a process when you're considering adopting anything new of how it will affect other stakeholders, of, what security risks something might present to data. Do you have any experiences to share with that, with how maybe things have moved more slowly than you expected because of those sorts of issues or others?
One big challenge, and falls along the line of your question, and that is redaction. So because all of our public case files are now open to the public, we have a requirement upon all filers, which includes attorneys, pro se, judges who file their judgments, to redact confidential information. And man, that has caused a buzzstorm in our state, because our lawyers are wanting to know what is confidential, and we give it a definition in our rule, but it's not an exhaustive definition. It's a definition of some examples. But, people's social security numbers, bank account numbers, maybe children's names, a lot of different information that in one case is confidential, but maybe not in another case. So they have to file a redacted copy as well as a clean copy. The redacted copy is the one that appears on our public case management system that's available to anybody in the world that has a smartphone or a connection anywhere. But it's been really tough to get this change adopted and accepted. Lawyers come into the clerk's office and ask these women and men that work in our clerk's office who are not lawyers, how am I supposed to do this? So it's slowly working, but it's a pain. I don't know if you guys have redaction issues in your states or not.
We do also require redactions of the personal identifying information along the lines of what you identified. And so folks need to file a motion. Usually it's in their appendices on appeal. Sometimes a few pages of their actual brief if it has to discuss something confidential, but they can file a motion to seal those documents, and then we have a way for them to file it under seal provisionally until we rule on the motion to seal, or to allow the filing of the redacted version publicly and then keep an unredacted version off the public access. Sometimes we don't need anything but the redacted version, but sometimes we do. So I don't know. We do our best to deal with that. I'm not sure how anyone else deals with those issues.
In terms of how stakeholders have accepted change or responded to change, I mean, have you found that even groups that maybe were initially hesitant about certain technological innovations eventually came around and learned to love it? I'm thinking about the electronic warrants that you mentioned, Chief Justice Russell. I mean, was that a hit right off the bat? Did it take some time to get everyone on board?
It was something that our prosecutor's office and others had been requesting for a long time. So that was one change that was somewhat welcomed. Even from my standpoint, I started reading briefs on my iPad. That's because we started electronic filing, as I said, back in 2011. And I was like, no way. I want my paper briefs. I like to cuddle up with them at home and read them sitting on the couch. And I thought, I do not want to read them on an iPad. Now you could not take this iPad away from me.
Hey, we need to chat after this, because I still love to cozy up with my hard copy briefs.
You can cozy right up with this little iPad, and it is wonderful. You don't have to carry that big stack of briefs everywhere you go. I would never go back.
Yeah, I still have a hard time reading briefs or a lengthy bench memo online. I mean, I can, obviously. I know how to access it, and I do, and I review some short things by email or in electronic form all the time, but the more lengthy substantive documents, I still have a hard time doing it completely
I'll show you.
on there. Although I do, like, I have come around to where when I'm editing others' work, I've gotten pretty good at the redlining N-words, so now that's the only way. And, I had to run kicking and screaming from using my red pen to edit everything. But so I suppose I can slowly learn to read it online. It is a hassle to carry heavy papers everywhere.
It is. We switched to e-filing. At least I think we're now totally filing in the state, except for limited jurisdiction we're working on. But we switched for appellate back in 2008 or 2009, and I was on our intermediate court of appeals then, and the chief judge, and I got everybody their iPads and all that. Well, what happened? They immediately start running the paper out because it's difficult to change. And as a consequence, people are going through toner cartridges like crazy. Well, those things are expensive. So I literally had to I said, well, I'm going to start rationing you people. So everybody gets a ration. You can buy your own toner cartridges. So that was what did it, because people just didn't want to change. They just wanted to run it out. But now, as I say, some of my colleagues still use a lot of paper, but I'm all electronic. And now we've gone to, I think probably you all too, with collective decision-making, get into a shared document so that all the edits and the comments and everything are all in one document. And that is so nice compared to how it used to be with lots of handwritten comments circulated.
I don't know. We're not there yet. We're not sharing. Like, we have the capability, but we're not doing it because of concern about, like, losing control of which is the current version of a document, the sort of master, so you don't have different people making different changes and then you lose track of which one is the final one that we agree on. So I don't know. We can talk about
after you talk to Mary, then you can talk to me about the shared document.
I think we're all going to stick around for a few minutes after this recording is complete. So looking ahead to what kinds of innovations are coming down the pike that you may be interested in personally, that your courts may be interested in. There's a lot of exciting stuff happening in the IT world, especially in the realm of self-represented litigants. A couple of you have mentioned ways that you're using technology already to help the public generally, but specifically self-represented litigants, things like kiosks in public places. Are there other innovations that you've heard about that you're interested in learning more about, or just ways in which you think the court systems are going to have to respond in the years to come to keep up?
Well, I think we have to talk about artificial intelligence.
Yes.
It's on everyone's mind. We've been talking about it quite a bit the last couple of days. In Michigan, we've already purchased licenses for a product that is a generative AI legal assistant, and we're piloting that with clerks and other lawyers in the system, and looking at the potential of using AI to write code for our case management systems. So we're making those steps, probably not as quickly as generative AI is changing, but I feel like we're as close to cutting edge as we can be.
Pretty cutting edge.
Yeah. And we've asked Michigan Legal Help, which is our national leader legal help self-help platform, to use AI to support access to justice for pro se litigants. So we're in this, and we're embracing it. I think we recognize that it's going to keep moving, and we can't stop it. So let's see how we can utilize it to help serve the public.
I've seen. I think we're doing the same. At least maybe not as far as Michigan has gone already, but wanting to proceed down that path with what AI can do for self-represented litigants, and frankly, to take the place of court employees that we can't keep. So trying to figure, well, what can we use human beings for certain things, but then they can use it as their partners to substitute for the people that we just can't get. But I have seen so many cool things that if only we had the money, it'd be great. But I've seen in LA County, for example, they have an integrated system for their counties, for all of their courts, and they have a gazillion of them, and they have they have $1 billion budget just for one county court system, crazy. And so they have something called Gina online, and I've seen it demonstrated where it's this woman named Gina, and she speaks like 10 different languages. And if you say, well, what can I do for you? I have a ticket. Well, where'd you get the ticket? And then it goes right into you personally and will walk you through saying, hello, Anne, I see you got a ticket for speeding and you qualify for defensive driving. And would you like to do this or would you like to do that? And in all these languages, well, they've gone from 4,000 people a week that have coming through their system, and you see pictures lined up to no one there, because it is just taken care of it so quickly and easily for them. So That's the dream system.
I would like to see Gina adopted in a lot of other settings.
Yeah, I don't know. We've got, in the kiosks that I mentioned earlier, it's funny because I hadn't thought about it as AI until we were in these sessions this week. And I'm like, I guess we are using AI. Because when you're asking questions to direct you to the right kinds of forms and to fill in the forms based on how people answer the questions and, yes, have availability in multiple languages, and then it translates it to English to file into the court. I mean, that's a cool thing that we're doing now. But I think I'm interested in what Justice Timmer was just talking about. Our courts in Las Vegas, the limited jurisdiction courts that deal with landlord-tenant issues, have had an overwhelming number of eviction cases since the prohibition on any evictions ended post-COVID. They couldn't evict during that time period, which made a huge backlog. And then trying to deal with those is a real challenge. And we're trying to use eviction diversion programs and other things to try to help. But many of those folks just aren't going to be able to keep paying the rent, and the rents keep going up. And, of course, then we have challenges with affordable housing, but that probably goes far afield from talking about court technology today.
Yes, AI is just the biggest thing that's going to happen to our world, and including our courts. And there was a quote given to us yesterday at one of our sessions that there's going to be more changes in the next 20 years than we have seen in the last 2 centuries. So that's like frightening. Hold on to your seats, and AI is getting better and better, and we're going to be figuring out the best ways it could help us in the courts and help our litigants, and trying to steer away from the areas that it's not helpful, that it's in fact wrong. I've been playing with AI for a little over maybe about 1.5 years, and I always enter a query of, please write a 500-word essay. Then I give my name and the court that I'm on, and it spits out real quick this essay. It's like 9 errors in each one. And I went to the wrong law school. It gives said my parents were both lawyers, that I was a judge in so-and-so court. I mean, and I'm thinking, well, this information is available everywhere, all kinds of websites. Why couldn't they capture that?
Right.
But then last week, I needed to write a letter of recommendation for someone, and I gave it the name of the award, the qualifications of this person, and it produced a beautiful product that I used 90% of. I made a couple of changes to be more specific in a few areas. Other than that, it was so helpful and saved me a lot of time.
One thing that I worry about with AI, there was some discussion we've had about whether it has built-in prejudices, if you will, which of course I'm concerned about. But even beyond that, and maybe just because of how much of a stickler I am in writing, I'm worried about freezing the kind of writing that is done in place. Like when you ask a generative AI program to write something, all it's doing is copying the exact way things that are publicly available have been written, depending on the style you tell it to use. But that means that what it produces is in the style that's been used before. And I think that unless we continue to edit and make it our own, it sort of freezes creativity and keeps things to be written in the same way they've always been written, or in the legal field or our field as judges to make decisions the way decisions have been made before that it's copying from. And obviously it's up to us to actually be the decision makers and not rely on AI, but I don't know, I worry about sort of freezing creativity if people use it too much in the legal field.
Well, it was interesting at one of our conference sessions yesterday, one of the panelists mentioned that he allowed his students to use AI to write their exam papers, and it brought the low-quality papers up quite a bit, but it didn't really improve the quality of the top students' papers, and that may be indicative of what you were just saying.
Right, if it's all just going to be the vast middle and sound the same.
And I guess that's the challenge we have, is figuring out, how do we use AI in a way that really accelerates and improves the quality of our justice systems. And I do think there's a lot of opportunity there, as you've highlighted. Justice Russell and others. And so I look forward to seeing what all of your court systems will do. And I'll especially be keeping my eye on Michigan. It's exciting to hear about what you have planned. I want to return just for a moment to funding. It sounds like we all have very different funding mechanisms. Some of us have legislative funding, significant legislative funding. Others are relying on court fees. Chief Justice Russell, I think you mentioned user fees that have been a source of funding in your states. It sounds like we all have to be pretty creative to figure out how to fund this. And it has come up a couple of times that using technology effectively in the judiciary benefits a lot of different stakeholders. It's not just about improving things for judges or, improving things for litigants. It's about making data more readily available, higher quality data, more readily available to policymakers, partnering with other entities that need access to this data. What are some ways that you have learned to be creative with respect to funding technological innovations? There are some grants out there. That right, Justice Russell?
Yes. As I said earlier, between grants and general revenue from the legislature and our $7 filing fee on every case, that's been pretty much all we've utilized as far as I know.
We've also, I don't know if this falls in the category, but there are a lot of court fees and fines and restitution that's just out there. Right? I mean, not collected, and we don't have the resources to go out there and collect it. So what we've done is use technology for it. We've gotten an outside vendor, and they get a slice of the pie. So I guess that funds it, and so it's called our FAIR program, and they've been tremendously successful at collecting millions of dollars now for these fines and restitution, finding people. They also have something called Pay Near Me, which has worked out really well so that people can go to a 7-Eleven or Circle K or Walmart or you name it, and they can just pay right there their court fines, and it will, within 30 minutes, registered, it's paid. And so we don't have to chase them down, and the private vendor handles that. And so that's the way I suppose we fund it that way, by letting them have a slice of that.
Until this past year, Nevada courts, we were funded in a significant part by administrative assessment fees in cases, but thankfully we were able to persuade the legislature to get us off of that and to be entirely on general fund monies. There were still administrative assessment fees, but it's not our job to collect them necessarily, and we're not funded with them. And there's been social justice type concerns about funding courts with fees and fines, and we're mindful of that as well. And the appearance of supporting your courts on the backs of the folks who find themselves in the system. So.
If we need all of you to come to Arizona and speed. I mean, that's amazing. That, or get the Michigan or Nevada legislators to come down and talk to our legislators about the benefits of that kind of funding. Because I agree with you entirely. You shouldn't build this on the backs of people's ills and woes.
I want to clarify that when I talk about the funding that we get, it's for our state court administrative office and what we do at the state level, and it's services that we provide to the trial courts. But we're a non-unified system, so we have a very large trial funding issue in Michigan right now that we are engaged in trying to resolve, because that's the problem that we have, is that it's fines and fees from the public that are funding it at the local level. So the success that we've had with the legislature and the support that we've had from the governor are on these more innovative things that we're trying to do to help on the trial courts in our non-unified system.
Switching gears just a bit, it's come up a couple of times that making what courts do more visible is a good thing for society. It allows people to have access to information they may need. What role do you think technology plays in civic education in our country? And I guess we're all hopeful that some students out there are tuning in to these live streams of arguments and whatnot. Have you seen any evidence that improving technology is allowing people to understand what we do at a higher level?
Making it available increases our transparency. If people want to utilize it, you can take the horse to water, but you can't make them drink. But if you have your court proceedings available on a platform where people go, whether it's an Instagram account or a YouTube account or whatever. When we explain court systems to people, they don't have to physically come to our building. They can press a button and lie in bed at night and watch a oral argument from like the state Supreme Court from the day before or earlier that day. And I think just making it as easy as possible for people to have access to the courts to see what we do really does help them, show them, and provide them the knowledge of what we do and access to our opinions, and access to other aspects of our work. I think definitely helps civic education.
Yeah, I think that the court TV drama type shows, either fictionalized drama or the so-called real judges, like a Judge Judy type show. I'm not attacking her personally, but in those settings, it shows judges being extremely opinionated and scowling at the litigants and, reprimanding people all the time and making jokes at their expense and those things. And that's like the opposite of the way a judge should act as a real judge on the bench. And so making available the videos of real court proceedings, I think, can help counterbalance that. Of course, it's not quite as interesting and dramatic when it's a real courtroom as opposed to those dramatized versions. But I think it's important to let people see the way real judges act, the way real courtrooms operate as part of their education, and to understand the court system and to gain more respect for how things actually work. Folks that come down to jury duty are always, not wanting to be there, most of them. But if they do participate on the jury and sit through a trial, at the end, they'll pretty much uniformly say, it was a really good experience, I learned a lot. And this is sort of, without having to be on jury duty, you can see what real court proceedings look like and learn from it and hopefully gain respect for it.
I think I've always been interested, too, in how I think about it, technology and the fact that our opinions are out there pretty quickly, and same with the trial judge's rulings, how it's impacted the judges writing those decisions. We know they're going to be read by a greater audience than the people that are just involved in the cases. And so I wonder if many of us now write differently. We really are trying to say something in the first paragraph, kind of sums it up in a way that I always think of anybody with a high school degree should be able to read and understand, no matter how complicated the case is. And I've noticed, I've been an appellate judge now for 24 years, and I've noticed that the trial judge rulings have changed quite a bit. Instead of motion denied, there's a lot more explanation as to, well, this is why, this is how I see it, and explaining it. And those things go out, immediately. So they're digested by a greater number of people. And I think that people, as talking about transparency, people are understanding more of what courts do and don't do in terms of making policy and don't do that kind of a thing. So that's been a positive.
Well, any closing thoughts? We have covered a lot of ground, but I would love to just give you an opportunity if you have any hopes about technology or any closing remarks to add.
Feel free. I would just say that it's great to talk to colleagues in other states and hear what they're doing. I wrote down a number of things that I'm taking back to Michigan for us to look at and say how can we make these improvements to serve the public better. So I just really appreciate having the opportunity to talk with you all and hear what you're all doing. And even though we may have different challenges in Michigan, it just that conversation about making improvements gets people thinking about what you can do. So thank you.
I echo that. It's a delight to hear what you all are doing, and that I can go back and say, well, this is what they're doing in this state, and how come we're not doing this? And so there's no need to reinvent the wheel when we have 50 plus now jurisdictions that are doing the same things and with the same goal, to serve the public. So I too appreciate that you invited us here to talk about it today.
I suppose, like many people, I have a hard time adjusting to change, and maybe I do use new technological resources and will learn them, but sometimes something new will come along and I'll think, like many, oh, it's working fine the way it is. But eventually I go along and realize it is a good thing. And I think as leaders of our judicial systems, we need to push ourselves to be thinking about how this makes it better for the judicial system and the state as a whole and the people that we serve as public servants, that it's not just about us. So we need to have that mindset, and I'm glad to be with a group of people who feel that same way and to help push me about what may be better for the way we conduct our business going forward. So I appreciate the opportunity.
Yes, thank you for having us here today. And change is hard, but stagnation is fatal. Right. The public expects this out of us. You can get your bank account information online right now. You can get your medical records. Why can't you get access to the courts as well? And although we are courts and government and are slower than all the other entities I mentioned, it's our duty as leaders to explore these uses of technology to the betterment of the people that use our courts. And I'm excited.
Well, thanks to each of you for your leadership in this area, for working so hard on these issues in your own states, and for sharing your expertise on them, both here at the conference and with all of us and our listeners. So thank you for being here today.